SJC-12555, Commonwealth versus Terrain, Tillis.
Mr. Shedd, good morning.
Good morning. My name is Dennis Shedd, and I'm representing Terrain Tillis. Mr. Tillis was convicted on a joint venture theory of armed assault with intent to rob, home invasion, and felony murder with home invasion as the underlying felony. Now, there's no dispute that Mr. Tillis took part in the home invasion and the armed assault. The issue at trial is whether he withdrew from the venture before the killing took place. And at the first trial, which ended in a hung jury, the judge gave an instruction on withdrawal from a joint venture. At the second trial, the retrial, he refused to give that instruction. Nevertheless, that was the sole defense counsel argued in closing, which raises two issues here. First, whether the evidence warranted a withdrawal instruction, and secondly, given that the judge refused withdrawal instruction, whether counsel as an alternative should have requested the judge to give a more detailed felony murder instruction that would have enabled him to argue that the killing did not take place in the commission of the home invasion in which he took part. Now, turning first to the withdrawal instruction issue.
Before you get there.
Sure.
In opening, did Mr. Tillis's attorney admit that he was involved? Or in closing?
In closing, certainly. He conceded he was involved in the home invasion and the armed assault, no question.
So the entirety of the trial involved not whether he had committed a home invasion, but whether he had committed murder.
Right. That was the only issue before the jury. So
I have a question before you get into the details of the withdrawal, or whether or not there should have been more explanation of in the commission of a felony. Wasn't the defendant also convicted of felony murder under a theory of home invasion?
yeah, it was felony murder with home invasion as the underlying felony.
Right. So as soon as they go into the house and show the gun in an assaulted manner, the felony has happened and the murder takes place there. It's not the armed robbery that has to end. The home invasion occurs and there you go.
But before the killing takes place, they're out of there, and I think the evidence would support a finding that there was an appreciable interval between their departure of Mr. Tillis, Mr. Okog, and Mr. Rivera.
They aren't even back at the car yet before they hear the gunfire.
Well, I think they.
Appreciable interval.
I think they are back at the car at that point.
Do you withdraw when you're scared away? Do you withdraw from it when you're scared away?
Well, it's not just that. So what happens here is these four people plan to rip off a drug dealer, and what happens is when Mr. Diaz resists, yells, "Call the police," and other people start watching what's going on. At that point, Mr. Okawuga says, "I'm out of here." He, Tillis, and Rivera run downstairs. Now, at that point, Lopez has noticed that everybody else is abandoning this venture. They're out there, giving up on the effort to rob.
I'm sorry, so we can keep track. When you say Lopez, are you talking about Ortiz?
Well, his last name was Lopez Ortiz. His father's name Lopez.
Okay, we just want to make sure we know the guy.
We want the right person.
The shooter. The shooter.
Yeah, it's Lopez, yeah. I mean, it's Lopez-Ortiz.
Got it.
Right, that's him. Yeah. Okay, so he is on notice that everybody else has abandoned this venture, and what happened after that would support a finding that there was an appreciable interval between that notice and the shooting. So what happens then, they run downstairs. Mr. Diaz runs after them. As he runs down, he says, "Don't call the police." He grabs Mr. Rivera, who hits him until he lets go. Those three run out of the front door. Mr. Diaz picks up a snow shovel, throws it after them, and at that point, he stops chasing them. Now, at that point, at least to those four, it looks like this incident is over and nobody's ever going to be charged.
Who do they think the shooter is?
They don't know where he is at that. They get back to the car and they're saying, "Where's Roberto?" They're probably assuming he's coming down with them. So they've lost track of him, basically. So as they're out of the building, Lopez has stopped the chase and told the neighbors not to call the police. So it looks like it's over. But unbeknownst to them, Lopez decided on his own to remain behind and continue his own effort to steal something. So After Mr. Diaz throws the shovel, Wendy Bond lives on the first floor, asks him, do you want me to call the police? No, I can handle it. She asks him if he's okay, and after that, he starts heading back up to the apartment. Now, around this time, Lopez comes out of Diaz's apartment with a gun drawn, and he tells Diaz's neighbor, Edwin Vega, to go back into his own apartment. Now, they go back and forth about this because Vega's worried that if he turns around, Lopez might shoot him. And Bond hears Vega say, there's somebody up here. At that point, Diaz says, I'll handle it. As he goes upstairs, he says, you did this to me, why? He gets on the landing, he and Lopez struggle, and Lopez shoots him twice. Now, that evidence certainly warrants an instruction on withdrawal. Lopez is on notice.
Under the predicate of the attempted armed robbery.
Yeah,
Under the predicate of the attempted armed robbery, right?
right,
Okay.
right.
The home invasion already occurred. Somebody from the home invasion is still in there, and there's a death as a result of that joint venture in the home invasion.
Well, the point is that there is a home invasion taking place, but my point is that at this point, a jury could find that Tillis, along with the other two, are no longer involved. There's a separate, the home invasion they're taking part in is over. What?
They all went together into the home.
They went together, they didn't leave together. They didn't leave together. So Lopez is on notice that everybody else has abandoned this venture. He has the same opportunity to leave that they have, but he chooses for his own reasons to stay behind. At that point, it certainly was not inevitable that Diaz would be killed.
He's not a free agent. He's got 3 teammates.
Not anymore, he doesn't. Once they leave, he has no teammates. He is on his own.
Well, we have all sorts of cases where somebody leaves and there's still no requirement of the withdrawal instruction.
Well, there's other cases.
Commonwealth versus Rivera, the relatively recent case, 2013.
Yeah, Rivera's a case where it's a mere matter of seconds between there's no announcement the person's going to leave, and a matter of seconds after he walks out the door, the shooting takes place. That's not this case. Here there's evidence from which it could be found there is an announcement, 3 people depart, and there is evidence from which a jury could find there's an appreciable interval between their departure and the time of that shooting. It's not like the Rivera case where there's no announcement. It's a matter of mere seconds. There's a lot happened between the time they left and the time this shooting takes place.
It's not an announcement, it's notice. The third prong on the withdrawal is notice. So you have to have notice to Lopez too, because he's on the team.
And that's my point. He's got notice by words and action. Okawuga says, I'm out of here, and they all 3 go out. Everybody goes out but him. He could have gone out when everybody else did.
How do you know he's not rifling through drawers in another room? It doesn't do any good to withdraw if somebody else is still there and doesn't have notice.
He did have there's no evidence anybody was ever in another room. Vega was watching some of this going on. Everything's taking place right around that doorway. Okawuga, they testify at this trial. Everything's taking place around that doorway. They're all together. Mr. Diaz is first on the floor, right near that doorway. That's what's all going on. And Okawuga is right there when he says, I'm out of here, and the 3 go. Lopez is standing right there.
Lopez has to know they ran out the door, is that what you're saying?
He couldn't miss it. He's got notice by words and action that they're out of there. He's got notice by words and action. And at that point, it's certainly not inevitable that Diaz would be killed. In fact, when they all ran outside, it would have been impossible for the shooting to take place because Diaz ran right downstairs after them while Lopez remained upstairs. He couldn't have missed the fact that, whoa, I'm all by myself all of a sudden. That was no secret there. So the evidence here certainly warranted that instruction, and it's very clear, even though the jury was never instructed on withdrawal, that the jury was thinking carefully about the argument that counsel made in closing, because they asked if and when a joint venture could be terminated, and that's a question they never got any answer to. So I think it's pretty clear, had a withdrawal instruction been given in this case, the verdict could very well have been different. Now,
when did the defendant learn that the judge was not going to give a withdrawal instruction? Before trial or during trial?
it was raised about 4 times. It first came up after the opening statements and before the evidence started, they discussed it on the record. At that point, the judge didn't indicate what he was going to do. He said, I'm going to think about it. And the next morning, he came in before the evidence started and said, I'm not going to be giving the withdrawal instruction. And it got raised 3 other times. The judge in this case gave instructions on the crimes and joint venture before closing arguments. And after that, those first instructions before the closings, it was raised again. It was raised again during the general instructions. He gave a lot of the general instruction, but then before the selection of alternates and instruction how to do the verdict slip, it got raised again, and then it got raised a 4th time later on. So the first time was before the evidence even started.
Mr. Lopez was convicted of murder too. Did he go to trial or did he plead?
He went to trial. He went to trial, yes. Yeah.
And got murder too?
Yes, he got 2nd-degree murder. Yeah, and that's one thing I just want to mention about the judge's decision.
How did he get 2nd-degree murder where it was a home invasion?
What was that?
How did he get 2nd-degree murder where it was a home invasion?
My understanding, I actually just talked about that with the attorney handling that the other day. We exchanged emails anyway, but evidently Lopez testified on his own behalf again, and evidently my understanding is his testimony was that there was only one gun involved. Okawuga had it, and Okawuga's the one who did the shooting, basically.
Oh, I see.
Okay. So he got acquitted of the armed home invasion because the jury wasn't persuaded that he knew that anybody was armed when they went in. He said Okawuga displayed the gun partway through this incident. That's the first time he realized it. So that dropped out the armed home invasion, dropped the armed assault with intent to rob, the simple assault with intent to rob. So that's what happened there.
All right, before you get on to whether the felony had been complete.
Yeah.
And for the killing.
Yeah.
I just want to, because I know it's not brief, but I still want to understand one more time, give you one more, the home invasion. So one of the elements of withdrawal is detachment from the enterprise before the crime becomes so probable that it can't be reasonably stopped.
Right.
Well, the home invasion's already occurred.
But the killing has not. And the question is whether the withdrawal took place sufficiently before the murder. And this is one of the points I forgot to make, was that when the judge denied the withdrawal instruction, he said he was denying it because the joint venture was to commit a home invasion and an armed assault, and those crimes had already been completed by the time of the withdrawal. And that's wrong on both the facts and the law. This joint venture was not to commit a home invasion and an armed assault. It was to commit a robbery, and that was not completed at the time. And as to the law, the judge overlooked what this court said in Hogan, which is a defendant can be found guilty as a joint venture of an initial crime, but then can effectively withdraw so as to avoid culpability for a subsequent crime. Now, in Hogan, it was a rape and then a murder, and the victim was stabbed, and the defendant said, I left before the stabbing took place. I took part in the rape, but I left before the stabbing took place. And the court said, and he was arguing the withdrawal instruction in that case didn't adequately inform the jurors that, in fact, you could take part in an initial crime, but then not be guilty of a subsequent crime.
Hold on just for 1 minute, if you could, please, because it's not a joint venture from the murder that he has to withdraw from. It's the joint venture from the felony which is committed in the murder's committed in the commission of the felony. He doesn't have to withdraw from the murder, he has to withdraw from the felony.
But if he's withdrawn from the venture an appreciable interval before the murder takes place, even though he's committed that.
One element of it, you have to detach yourself from the enterprise before the crime. The underlying felony here is so probable that it can't reasonably be stopped.
Well, in this case, my point is that the felony that Tillis took part in, the home invasion, is not connected in any way to this killing. They were out of there an appreciable interval before this killing took place. I mean, the simpler, Tillis, Okawuga, and Rivera.
But the other co-venturer.
Rivera
who
is
was a co-venturer in a home invasion.
Right, but Lopez at that point is on his own. He is engaged in his own home invasion, trying to continue to steal. He's got an intent nobody else even has anymore.
That's your next argument.
What?
That's not the withdrawal argument. That's your next argument.
No, but the point is also they withdrew well before this killing took place. And it could be found that took part, I mean, it's no different than the Fickett included home invasion, felony murder. Which cases? Allen was a felony murder case. Smiley was a felony murder case. Hogan was a felony. All of those are felony murder cases. And
Allen
they've held
says,
that
I don't want to go in. He didn't go in. The co-defendant threatened him if he didn't go with them, and then he didn't do anything at the scene. It's pretty distinguishable.
I'm sorry, I missed that.
Allen, he's threatened, and he says he doesn't want to participate. He's threatened.
Yeah, and Allen, he said, yeah. So, but there's these other cases, like Allen is one. I mean, he says, he's sitting outside, says, I don't want to go on with it, and the guy threatens him and makes him go up.
Right.
Felony murder case. Fickett's a felony murder case. The guy says, I don't want to take part of it. Nevertheless, he stays with the other person the entire time and takes part of the proceeds from the crime. And a withdrawal instruction was warranted. And if it's warranted in those cases, I believe it's equally warranted in this case, because plenty of evidence that these people withdrew, but well before the murder. Lopez had the same opportunity to withdraw that they had. He chose not to take advantage of that opportunity and continued on his own.
Well, maybe you should argue about that it didn't take place during the commission of the felony, that the felony was complete and you didn't get the more detailed instruction, because it seems to be what you're arguing really is that the felony is so disconnected from the killing that it wouldn't constitute felony murder because it wasn't committed in commission of the felony.
Well, that's certainly the second argument, but I also believe it's not connected. It's still, I think there's plenty of evidence of withdrawal here. Just the fact that they leave, announce they're going to be leaving, they do leave, and Lopez could have left at the very same time they did. There's plenty of evidence there to support the withdrawal instruction, I believe. As in the Hogan, in Hogan, where the court said you can be guilty of an initial crime but not be guilty of a subsequent crime. I think that instruction should have been given in this case. So turning to the other issue, so in this case, even though the judge had denied the request for withdrawal instruction, that's the only issue that was argued in the closing argument. So in effect, as a result of that, Tillis was basically left without a defense because the jury never heard that there was any legal basis for the defense he had suggested. But there was an alternative that could have been raised in this case, which is that in DeLello and Green, this court stated that if a killing occurs after a felony is completely over, which is defined as there being an appreciable interval between the alleged termination and the killing, then the killing is not connected to the felony. And the court said that whether the felony is completely over is an issue for the jury to decide. So in this case, when the judge declined to give the withdrawal instruction, counsel could have asked him to include a DeLello Green instruction in the felony murder instruction, which would then have enabled him to argue that the home invasion Mr. Tillis had participated in had ended well before their murder. There was an appreciable interval between when they left and when the killing took place, and therefore the killing was not committed in the commission of the felony.
But why had it ended? Lopez Ortiz stayed in order to steal the drugs that they were there to steal.
Right, but but my point is here, there's basically two separate home invasions at this point. 3 people have abandoned the effort. They've gone, the home invasion they've taken part in is over. Lopez, for his own reasons, has decided to continue this on his own. He's on his own trying to find something to steal. So he's open to argue that the home invasion that the other 3 had taken part in was done. They were out of there, they're finished. There's an appreciable interval between the time they leave and that killing. Now, counsel never considered requesting a DeLello Green instruction, even though it would have supported the argument he wanted to make. And it's clear from the jury, even though the jury never got instructed on a withdrawal, they indicated they were looking at this very instruction, whether the killing is committed in the commission of the felony. And that's when they asked if and when a joint venture can be terminated. So had that instruction been given, this verdict could well have been different.
You understand there's an inconsistency in your argument. One of the elements, again, is on the withdrawal, a detachment from the enterprise before the crime becomes so probable that it can't reasonably be stayed, talking about, I'm here referring to the first home invasion. And then you're also saying, you're also saying that the home invasion was over.
I don't believe, Aaron. I'm looking at I'm asking,
You understand my question, though?
yes, I do. They're not at all inconsistent.
Okay.
Because the two instructions are focused on two different crimes. The DeLello Green instruction asks whether the home invasion, the felony, is completely over before the murder takes place. The withdrawal instruction is asking whether they have withdrawn before the murder took place, before the murder was committed. So they're focused on two different crimes. And the other point here is that I'm not suggesting,
There's no separate crime for murder. It's a felony murder theory.
but if they've withdrawn an appreciable interval before the murder takes place, and in that case, as in Fickett and as in these other cases, you can withdraw, but you can commit one felony, but then withdraw before the murder takes place, and that's what happened in this case.
In a light most favorable to the defendant, what's the time frame?
What's that?
What's the time frame that we're talking about between the shooting and the withdrawal? In a light most favorable to the defendant.
Well, there's no clock on this, but it's a
know,
time
no,
necessary. It's a time necessary for Diaz to follow them down, saying, "Don't call the police." Time for him to grab Mr. Rivera. Time for Mr. Rivera to fend him off. Time for them to go out the side. Mr. Diaz gets down, throws the shovel. Time for him to have this conversation with Wendy Bond. Time for him to talk to Lopez as they go upstairs. Time for him and Lopez to struggle, and then the shooting takes place.
In Commonwealth versus Moran, we said 30 minutes was not enough, was fine.
I'm sorry, I couldn't.
In Commonwealth versus Moran, we said a 30-minute time frame we could find was causally related, one event and another event.
Well, Moran's a different issue. Moran's the question, is the evidence sufficient? That's not the issue. And the issue is not the sufficiency of the evidence. I'm not arguing that Commonwealth presented insufficient evidence that, to convict Mr. Tillis. The point is that looking at the evidence in light most favorable to
You say it was
Mr. Tillis,
an
his instructions were warranted.
I got you.
Yeah, okay.
Okay, thank you.
Just to wrap up, due to the errors that occurred this trial, Mr. Tillis should be given a new trial, but should the court determine a new trial isn't warranted, at the very least, this case ought to be reduced to second-degree murder. As the Chief Justice alluded to earlier, while Mr. Tillis, who was out of that building before the shooting took place, has been convicted of first-degree murder, Mr. Lopez was convicted of second-degree murder. And I realize that doesn't raise any legal issues. Different juries can come to different verdicts, but it certainly is a matter of justice and fairness. Mr. Tillis should not stand convicted of a greater crime than Mr. Lopez.
Okay, thank you.
Thank you.
Mr. Charles.
Good morning again, Your Honors. Assistant District Attorney Jamie Michael Charles for Middlesex on behalf of the Commonwealth. This case is really about how far this court is comfortable with allowing a defendant to go and completing a predicate felony that results in a felony murder conviction before he is deprived of a withdrawal defense. And I think Justice Lowy hit the nail on the head here. This court's own model instructions say, quote, "The defendant must withdraw from the planned crime before the commission of the crime has begun." The planned crime, the predicate felony. And here, both the armed home invasion and the armed assault with intent to rob were complete at the time that this defendant allegedly withdrew, as he characterizes it. The Commonwealth would characterize it as an escape, but in any case, I do want to acknowledge very briefly, the defendant was right in his reply brief. The Commonwealth did err somewhat in describing the state of the post-shooting conduct vis-a-vis what is most favorable to the defendant. Based on the defendant's interview, he did in fact deny that he had done anything after the shooting beyond get back in the car with everyone and go back to New Hampshire. So he didn't actually say that he helped clean the car, dispose of the gun. But notwithstanding that, if we look at what happened up to and through the shooting, even in the light most favorable to the defendant, based on what he said in his interview, which is in my brother's record appendix, he admits to planning the crime with the others. He admits to knowing that at least one of the individuals, the ultimate shooter, Lopez Ortiz, had a gun. He admits to communicating with Mr. Grays, who was acting as a lookout, and that they all cumulatively, and I can give page sites if necessary, but he agrees that they jointly decided to go into the house. He admits that he covered his face before he went in, that he had a knife on his person when he went in, that they went into the apartment, went up the stairs, there was a physical struggle with the victim in the threshold of his apartment, that several of the individuals in the joint venture, not this defendant, but at least one or two others, actually crossed the threshold and went into the apartment, and that essentially, I believe he said, when shit got out of hand, pardon my language, when Pedro started hollering and shit, it was like we exited. Somebody in the hallway screamed gun, and then we ran. So they've completed the crimes, he's actively participated in the planning and execution of the crimes, and he's simply leaving because the circumstances have turned against him. That is not withdrawal. It's certainly not timely withdrawal. There is no way you can determine that Lopez Ortiz, who was already in the apartment with a gun looking for drugs and money, which was not disputed at any point in the trial, has a reasonable opportunity to abandon the crime at that point. So this is untimely withdrawal based on this court's own instructions. It's fairly on par with the Cook case, where that defendant said, I participated in a beating, but before they took the jacket and stabbed the guy, I left, and I went back to the van, and then the actual stabber came back to the van and informed me that he had stabbed the victim and that the victim had died. This is essentially the same case.
You have the home invasion, that's been completed as soon as you have an assault at least separate from the killing. Once you have the attempted armed robbery, they go in the attempted armed robbery, then the attempted armed robbery part is completed.
Yes, I think from an elemental perspective, I agree with
It
you.
is basic as you can.
Yes.
Attachment from the enterprise before the crime becomes so probable it can't be reasonably stopped.
Correct, and that's why I think you've distilled it down to its essence, and the defendant on these facts is not remotely close to being in a timely position such that he would be entitled to withdrawal.
So nothing's free, but the weaker the withdrawal argument is, and it seems awfully weak, the more concerning the ineffective assistance of counsel is on the disconnect between the felony and the killing.
I don't necessarily agree with that, because I think there has to be a distinction between you've satisfied the elements necessary for conviction of the crime and the actual crime is over. So I'll just start with sort of what we traditionally refer to as like the second prong. I understand that the analysis is a little different in the context of 33E, but in terms of assessing was there a substantial likelihood of a miscarriage of justice, there's no dispute that Lopez Ortiz was a member of this joint venture, that they jointly planned to do an armed home invasion and armed robbery, and that he remained in the house performing the duty that was ascribed to him beforehand, to look for money and drugs. So I don't think there's any way that, although Mr. Tillis and several of the other joint ventures may have untimely abandoned the crime is still ongoing. The fourth member of the joint venture is still in the apartment, still looking for money and drugs. There's no dispute that that was what was happening. Even the defendant doesn't dispute that that's what was happening. He tries to create this sort of fantasy characterization of a new home invasion, but you can't realistically claim that this is a new home invasion when he's still doing the job he was originally assigned in the original home invasion to get drugs and money, and then he shoots the victim moments after they flee in his own effort to escape. So it's not really a cognizable claim that the felony was actually over. But even, above and beyond that, if we sort of backtrack to what's the first step, was there error in the first place? You have to look at what was going on here from this attorney's perspective. The first trial ended in a hung jury 1 month before the second trial. He got, I would argue he shouldn't have, but he got a withdrawal instruction in the first trial. He came into the second trial a month later believing he would get a withdrawal instruction. My brother accurately characterizes how that discussion went. After the view on the first day, post-openings, there was a discussion. The judge says, I'm not really inclined to do it, but I'll think about it. On the following morning, before actual evidence starts, he informs the defendant that he is not going to give it. The jury instructions happened 2 days after that. And the trial counsel, to his credit, continued to persist in his requests post-closings into the jury instructions to try and persuade the judge to change his mind. And I would argue that that wasn't unreasonable in light of the fact that he was able to get a withdrawal instruction in the first trial. I'd also just note that if you look at these, we're talking about two cases that are 60 and 80 years old respectively, that are not widely cited in the case law. Where they are cited, I think if you look at it, they're not actually cited for this proposition that DiLello speaks of. they're really routinely cited for withdrawal purposes, because Green also talks about the defense of withdrawal. So to suggest that a defense attorney who had been successful in the first trial getting withdrawal instruction, at the second trial a month later, who's informed after openings that the judge is not inclined to do it, that he should just intuitively know of these ancient cases and request some sort of elaboration on what is a fairly detailed and well spelled out definition of third-prong felony murder, not third prong, but the third element of felony murder, right? It informs the jury that the murder must happen in connection with the felony at substantially the same place and time. It tells them that they may but need not consider efforts during an escape as being part of the. So if the jury were to reach a determination that the escape was not part of the felony, or if they were to accept the argument that the defense attorney was trying to make in closing, which is that the felony, as we understand it, the home invasion that these individuals jointly agreed to do, was over because 3 of the 4 ran out of the apartment. If they accepted that, they absolutely could have found, I'm not saying I think that would have been a legally correct verdict, but they could have made a determination that the felony was, for all intents and purposes, over, and that the shooting was not in connection with it.
Argue it, and he didn't have, and he didn't have the opportunity to have the wind behind his back of the judge's instruction after argument.
So I think it's also important to note that as opposed to withdrawal, which is essentially, what we call an affirmative defense, the defendant here was only asking for the court to elaborate on a specific element in a manner, by the way, that is not sort of, I don't want to say sanctioned, because obviously the model homicide instructions, they have your blessing, but they're not the law. They stay in the introduction that if a case requires, you should instruct further. But I mean, nowhere do these cases appear in any of the supplemental instructions in the model homicide instructions. It's not a common instruction to be given. So to suggest that we have ineffective assistance that created a substantial likelihood of a miscarriage of justice because this attorney didn't ask for a couple of additional lines explaining what it means for a killing to be or not be connected to a felony, I don't think would have necessarily carried the day. I think the instruction's pretty straightforward. Either it occurs at substantially the same place and time and is in connection with, or it doesn't.
But he didn't argue it. He didn't argue it in his closing, though, did he?
So the closing was framed in terms of an abandonment, but I think if you read the closing in its entirety, what counsel was trying to essentially get across was that the shooting was so far removed from the time that these other 3 joint venturers left that it wasn't actually connected to what they had gone into the house to do. That because the victim had left the apartment with them, chasing them out, and because he was removed from the situation, it wasn't as though those 3 left and in the apartment the victim remained and was shot by the 4th. It's the victim left, chased them out, and then came back to the apartment and separately engaged in the hallway. That was the thrust of the closing argument.
But is there any prism here of looking through the jury instruction that never had a chance to be answered?
I'm not sure that that's an appropriate consideration because, first of all, there's no indication that there was any effort to deprive them of an answer. They simply reached, I believe the verdict came 1 hour after the question. So it's not as though anyone was trying to deprive them of an answer to the question. And if I'm being candid with you, I'm not really sure there could have been an appropriate answer that would have benefited the defendant, because while the answer to the question of can a joint venture terminate is unquestionably yes, but the second part of that question was and when. And I think then we're sort of getting into the withdrawal that the defendant really wasn't entitled to, because while the joint venture may have terminated at the point that 3 of the 4 turned tail and ran, that doesn't get the defendant anything in terms of his liability for felony murder, because the felony was, from an elements perspective, complete. So I don't think the judge could have just given a plain yes answer to that question. It would have required a lot of, as several of your honors are aware from having been trial court judges, often the better practice is just to say, I refer you back to my instructions, because we don't want to run the risk of confusing the jury or unnecessarily focusing them on a particular point. And then obviously I'll also note, which is sort of, it's commonsensical, but I mean, it could have just been one juror that was asking for some clarification. It doesn't necessarily suggest that the entirety of the jury was focused on this point. We get questions all the time that we later find out were the product of, one holdout had a request for clarification or somebody just got tripped up with the wording. So but I think just to circle back to what I started with on this second argument, you can't say it's a substantial likelihood of a miscarriage of justice where the victim was shot by the fourth joint venturer who remained at all times armed, at all times in the apartment, at all times doing the job that was ascribed to him at the meeting beforehand at Kent Gray's house to look for drugs and money, and that he then shot the victim moments after exiting the apartment while attempting to make his escape. Wendy Bond, in her testimony, it's at volume 4, page 25, characterized the incident as happening quick and fast, the whole thing. You know, obviously, Morin is sort of the broader end of what can constitute the res gestae of a felony. I don't think you have to go that far here. I think at most, we're talking about a minute or 2 minutes. The testimony in the light most favorable to the defendant was that they had just reached and possibly entered the car when they heard the shots. And the jury went on a view, and they knew that this car was not first of all, this was not a very big apartment building. It would have taken them a matter of seconds to get from the victim's apartment out the front door. And it also would have only taken them a matter of seconds to get from the front door to the car, and the jury and the judge would have known that, having gone on the view and being familiar with the surrounding area. So this all happened very quickly, and I don't think that even if you want to accept that the felony was quote-unquote over, I don't think there's any reasonable view of there being an appreciable interval between whenever this felony was quote-unquote over and when the shooting happened. So in the context of an ineffective assistance claim, where we're saying he should have done this and you should just assume that it prejudiced him to not have it, on the facts I've sort of outlined for you, where he got the withdrawal instruction in the first trial, where this is not language that is readily prevalent, that is suggested in the model homicide instructions, I don't think that you can say that the absence of this instruction on the facts of the case created a substantial likelihood of a miscarriage of justice. And if there are no further questions, the Commonwealth would ask that you affirm the defendant's conviction.
I'm sorry, I do have one
no
on
problem.
33E.
Sure.
We're going back to a question I asked in the last argument, Commonwealth versus Tejada, where, revise and revoke, the judge can consider the disparity of sentence of a co-defendant. Is that playing to any 33 analysis here?
I don't think it should be here for this reason. My brother did, I will say, I think fairly characterize what happened at Mr. Lopez-Ortiz's trial. And he's actually, it's neither here nor there, but he's actually filed a Rule 25b2 motion now to further lessen his verdict in light of Brown and other considerations. But Mr. Lopez-Ortiz decided to take the stand. That's something Mr. Tillis didn't do. And Mr. Lopez-Ortiz, for better or worse, fabricated, or well, that's the Commonwealth's position, but testified to a chain of events that essentially exonerated him on all the key points. Did he go into the apartment? Did he know there was a gun? Who was the actual shooter? The Commonwealth's two cooperators, Mr. Rivera and Mr. Okawuga, did testify at that trial, and they did testify consistently that Mr. Lopez-Ortiz was the shooter, but they had testified multiple times previously, and they were subjected to heavy cross-examination based on their prior inconsistent statements. The Commonwealth's other precipient witness, Mr. Vega, was a drug user. He was heavily cross-examined about his drug use and his ability to perceive. Did Mr. Lopez-Ortiz have more effective trial counsel on those points? Possibly. And that enabled him, along with his testimony, to obtain a verdict of second-degree murder. But does that mean that Mr. Tillis, on the facts of his case, was not guilty of first-degree felony murder, at least in a pre-Brown sense, and that the weight of the evidence wasn't in favor of that verdict? I would say no. And so I'd ask that you not exercise your 33E review and affirm the convictions.
But it ultimately means that the guy who did the shooting and the guy who you say lied on the stand is doing better than the guy who effectively said, yeah, I was part of the home invasion, but I didn't do the shooting. And
I can tell you that there's very few people on this planet that are more troubled with that outcome than myself, frankly, given my familiarity with the cases. But jurors, that's when you put your case in the hands of a jury,
but I know
the evidence was different.
The issue is it's now in our hands, and we have the ability under 33E to correct that and to drop it to murder 2, as we did in Brown. The facts in Brown obviously are more favorable to the defendant, but
I think, as I said in my brief, this defendant's not even remotely close to the sphere of what Brown
Right, I get
did.
that. I understand.
He was on, he suggested the target, he participated, he knew guns were involved, he went in.
It's not an outer fringe case, we get it.
It's not an outer fringe case, and while I think, to put it this way, had a jury returned a first-degree verdict against Lopez Ortiz, I don't think anyone would have argued that that verdict was against the weight of
Right,
the
I
evidence.
understand that. But the other thing, which I guess is somewhat troubling, is that defense counsel in this case goes to trial believing, in good faith, he's going to get the same instruction on withdrawal he got in the last case. And the whole case appears to be predicated, the whole defense is predicated on a defense he was given in trial 1 but was not given in trial 2.
Same judge too, right?
Same judge, that's
Same
correct.
judge?
And I guess what I would say to that is first of all, he knew about it at a minimum before the testimony was elicited. And I would say more importantly though, I don't believe Mr. Tillis or the defendant really had another defense to put forward. The evidence was fairly compelling as to his role and to the timeline of events. So I'm not really sure what else a competent defense attorney would have been able to do at trial,
he could have-
other than to sort of suggest to the jury that because these three ran out the door some approximation of time before the shooting, and because the victim followed them, that there was this line drawn between the old crime and any new crime. And that's essentially what he did in closing, and it wasn't
Right, no, I
ultimately
understand he
successful.
did what he thought he could, given what he had. What he could have done is plead if he had murder 2 as an option. Was murder 2 an option? If he had pled?
I don't have intimate familiarity, so I don't want to misrepresent the record, but my understanding, based on my conversations with trial counsel, is that this particular defendant was not interested in any way, shape, or form in plea bargaining with the Commonwealth, and in our efforts to proffer with him was not particularly cooperative.
Okay,
But that's all I can really say.
okay.
Thank you, Your Honors.